You're not at it?
I'm sorry?
You're not at the hearing in camera? Who's at the hearing?
My understanding that the in-camera hearings are conducted in the presence of counsel, Your Honor.
So
it would be the trial judge, it would be a representative from the state, and it would be counsel for Mr. Murray would be present. Or I believe that the court has the right to fashion the in-camera review and make its own determination outside of the presence of counsel to determine whether or not the exemptions that have been claimed.
So the trial judge would be required, in addition to whatever else they do every day, which is considerable, they would have to go through cartons and cartons and cartons of boxes, either by themselves or with some combination of counsel present, to understand what it is before they calculate whether it's subject to the exemption.
Your Honor, and when I use that word require, that language comes directly out of this court's decision.
No, I'm just asking.
That's what you said. You require to determine whether or not there is a total or a partial withholding of the record.
No, I understand that. I'm just trying to get you to either agree or disagree. What I've laid out as a scenario is what the trial judge would have to do.
That is correct.
Okay.
And I believe that's what the requirements of the New Hampshire right to know law are, of Article 1, Section 8 of the New Hampshire Constitution, and I would suggest that that's what the requirements are under 5 U.S.C. 552b7. They are required to do that exhaustive investigation, to look in its files, to take those records and segregate those records which are not subject to a claimed exemption and produce them, and then to establish with specificity those records which they claim fall within the exemptions, and then the court has the right to review that to determine if the claimed exemption is in fact valid.
And then if it's appealed, do we review the documents ourselves? If the trial court says you don't get this and you appeal it, we then sit as a trial court and look at the documents ourselves. How does that work?
I would believe, Your Honor, that it would fall under the court's normal review of a factual decision, and I guess it would not be disturbed unless it was a clear error of law.
But how would I know whether the court's factual conclusion was correct if I didn't review each document that they kept from you?
Well, again, factual determinations are reviewed on an abuse of discretion standard, and I would suggest that would be the review that this court would employ, but at a minimum, some court would have reviewed what the state is doing, which is the whole purpose of the right to know law.
No, I understand.
For citizens to look and see what they're doing.
Factual issues come up here, we look at the record to see whether the record would support the finding. So if a judge says this document is not to be given, if that's a factual finding, I can't wear a blindfold. I have to look at the document, don't I, to say a reasonable fact finder could conclude.
Correct.
So we would have to review all the documents here.
I believe that that's a possibility, Your Honor. It would be, I would assume, submitted under seal, and the court would then consider it as part of its overall review of the record.
All right.
And I see that I'm out of time, so if there's any other questions.
Thank you.
Thank you.
Good morning, Your Honors. I'm Nancy Smith. I'm here today on behalf of the state of New Hampshire defendants, as well as the county and municipal government organizations that were named as respondents here. And first, I would like to say that we empathize and sympathize with Mr. Murray's concern over his daughter. I can't imagine a father that wouldn't be concerned about the disappearance of his child. But when we consider whether a record is a public record under 91A, we're not allowed to look at the relationship of the person who is asking for that record to the subject matter of the record. Although we don't in any way suggest it's the case here, what we are being asked to do in this case would open up the state of New Hampshire law enforcement investigatory files at a pre-indictment stage to the suspected perpetrator as well as to anyone else in the world.
Shouldn't the state at the very least concede that it's a criminal investigation? I gather the state hasn't even done that.
I'm sorry, I didn't quite hear your...
It's my understanding that the state has not even conceded that this is a criminal investigation. Shouldn't that be the least the state should do as a premise underlying the problem?
Okay. Because of the facts of this case, we don't have a body. We can't say for sure if Maura Murray is alive somewhere. We can't rule out that she may have left of her own volition. So we cannot, for with 100% certainty say that a crime has been committed.
How does it interfere with a law enforcement proceeding? How does the disclosure interfere with a law enforcement proceeding?
We do have information that we are pursuing that this may involve a crime. And as with any possible homicide, if that's what this is.
Is that the burden the state has, that it may involve a criminal investigation, or does it have to say it will interfere with an ongoing criminal investigation?
The standard is whether there's a reasonable likelihood. We don't have to prove with 100% certainty that what we are investigating involved a crime.
How would the trial court here, I've looked at the list on page 100, and I've read the trial court's finding, which says the court finds that they should be exempt, the documents, from disclosure because production of the records would clearly interfere with enforcement proceedings. First of all, what enforcement proceedings would it clearly interfere with? And secondly, how would you know that by just looking at those broad categories?
Looking at the facts of this case, we have an identified individual. So this is a lot different than the Chicago versus ATF case where you're talking about data about lots of handguns, whose disappearance is being investigated. We have specific records related to the events surrounding her disappearance.
Is that a law enforcement proceeding?
Yes.
So it's a missing person?
It is a missing person who we are investigating whether or not a crime is involved in connection with that disappearance.
How would the disclosure of maps and diagrams interfere with the investigation?
Her car was found. I have not reviewed the specific map and diagram, but I'm assuming that it involves the area in which the disappearance occurred.
Sure.
There were searches done. There may have been maps done of the area searched and what they found, or the point to which they could trace her, because as I understand, the dogs did trace her scent for about 100 yards. And that information, as far as the specific spot in which she disappeared, if they have a suspect, if there is foul play involved, knowing exactly where we determined the last place she was, could be valuable information to that person.
Is that what the record would support, to support your burden, to show that there's a reasonable likelihood that this is going to interfere with a law enforcement proceeding on that issue? Isn't that your burden?
Yes, and it is our position that we satisfied that burden with Judge Vaughn. We produced, based on that detailed review of the records, in order to categorize the documents that we have and place them into these 20 categories. We did a detailed review of all of those documents. At the hearing, Attorney Mullen from our office, who I wish was here today talking to you in place of me, since he's more familiar with this case than I am, he brought with him the chief of our homicide unit, Attorney Strelson, who has been working with this case, as well as Chief Giacone, who were available to be put under oath and testify to the judge, and an offer of proof was made that these records were actively being used in investigating this case.
If that's enough, then you can never penetrate that wall. How do you penetrate that wall? If you're, like the father in this case, saying, I want records, and the police come in and say, well, we're using all these records, and the judge says, well, if you say you're using them, I guess there's nothing I need to do here. Well, what's the judge there for? To find out whether they believe the police or what?
I believe that counsel could have requested that Chief Giacone and Attorney Strelson be put under oath and their testimony be placed on the record.
But they're not going to disclose, are they, under oath? Well, why would they do that? Why would the court say, well, you can't see the documents, but you're free to ask them what's in the documents? They're going to say, I'm sorry, I can't tell you. It's going to interfere with ongoing investigation. So to go back to my question, if the judge isn't looking at the documents, but merely accepting the credibility of a police officer, then the answer to my question is you never penetrate it.
There are...
And if that's true, and it probably is because you can't think of an answer to the Chief's question, how much time passes? In other words, if 5 months is okay under Bowman, but otherwise if we say it's, subject to the exemption, nobody can penetrate that, 2 years, 3 years, 10 years, what?
Well, as an example, and this was also mentioned to Judge Vaughn at the hearing, our office has recently been able to bring indictments and bring to justice people in 2 20-year-old murder cases, in the Knickerbocker and Windhurst cases.
You're suggesting that the rule should be on basically closed file. Miracles happen. On a 20-year-old file, you think you could go to court and the police could say, well, we haven't totally given up, Judge, and it could interfere. You never know. Of course, I was here. It probably could interfere if you tell me that. I mean, how does one ever get to the document?
An example in the cases that is cited is the Dickerson case, which is the Hoffa disappearance.
We still haven't found him, have we?
Pardon?
We still haven't found him, have we?
We still haven't found him. He could be alive somewhere, although I think he'd be quite old at this point. But the court in that case upheld the withholding of documents in a very old disappearance.
Is this case any different if it's a newspaper making the request and the victim is a high-profile governmental official?
Which is basically the situation in the Hoffa case. I believe.
I don't know if he's a governmental official, but he's high profile.
Well, right,
but I mean, it's a case where there's not just the family that's interested, but there's general public interest in the disappearance. Is it a different case? A different balancing?
The sheer volume of documents in that case, if they had a collection of things that were otherwise public, like if they had a collection of newspaper clippings that were sitting in their file, those documents that are public that aren't...
I understand that, but where there's a heightened public interest in the disappearance of someone, shouldn't there be a more liberal standard of disclosure?
I believe that the obligation on the government is to protect we have conflict. We have two obligations. We have an obligation to comply with the right to know law, but we also have an obligation to bring to justice people who have committed crimes. And we have the obligation to look at our file and make sure that releasing information from it is not going to harm our ability to bring people to justice.
Let me go back to the Chief's question earlier. Putting aside the fact that there are 2,500 documents here, I mean, the volume doesn't matter, whether it's 3 documents or 2,500 documents. What's to be lost from having a judge look at them ex parte without counsel present to determine whether or not they should be disclosed?
The loss, as Justice Broderick has suggested, is a burden in potentially every criminal case in this state, and the judge being asked to look at volumes of documents. And I would point out that the cases that we have cited do not say that in-camera review, and that's very clearly stated in the Eli case that my colleague cited. The in-camera review is to be rare. And it is to be reserved for those cases in which the exceptions claimed are few and the documents are also small, and that it is the exception rather than the rule.
If you don't do that, and if you don't have if you don't look at the in-camera review and you don't have a Vaughan index, then all you're doing is relying on the representation of the prosecutor, whatever. The judge, this is an investigation, and disclosure will likely interfere with the process, right? Isn't that right?
No, Your Honor. We do have the obligation, which we fulfilled in this case, and it's contained in that categorical listing of documents on page 100 in the appendix. There are 20 categories, and just to read a few of them, there are phone records, there are subpoenas, There are credit card information, criminal records checks.